Confidentiality and disclosure of student meal statuses. This is presented by the Arkansas Department of Education, Division of Elementary and Secondary Education, Child Nutrition Unit. Goals and objectives. This presentation will inform superintendents, child nutrition directors, determining officials, and other district personnel of the requirements for confidentiality and meal status disclosure. Make known the importance of maintaining confidentiality of meal applications and categorical list. Discuss preventing overt identification of students and the penalties for overtly identifying a student. List federal, state, and local programs that may obtain a student's eligibility. Reveal when parental or guardian consent is required for disclosure. Important facts. Districts or LEAs are prohibited from distributing and processing applications solely to obtain household income information in order to obtain the funding or benefits for programs other than the child nutrition programs. Any attempt by a school district to obtain individual income information for the purposes of funding must not be associated with the child nutrition program, and the child nutrition program free and reduced meal application cannot be used. The district must seek written consent from the parent or guardian to use the information provided on the application for the non-program purposes or for purposes not permitted by the United States Department of Agriculture, USDA Guidance Manual. Consent must be obtained each school year, and consent forms cannot be extended from one school year to the next. What is disclosure? Revealing or using individual children's program eligibility information obtained through the eligibility process for a purpose other than student meals. Disclosure includes, but is not limited to, access, release, or transfer of personal data about children by any means. It includes eligibility information obtained through meal applications or through direct certification. LEAs must prevent overt identification of student meal statuses. Overt identification is any action that may result in a child being recognized as eligible or certified for free or reduced price meals. Districts must assure that overt identification is avoided at any step in the process of providing free or reduced meals. This includes notification of the availability of free and reduced price benefits, certification and notification of eligibility, providing meals in the cafeteria and the point of service. Aggregate data disclosure. The district may disclose aggregate data to any program or requester when individual children cannot be identified through release of the aggregate data or by means of deduction. An example of aggregate data is the total number of children eligible for free and reduced price meals in the school district. Since this type of data does not identify individual children, parental or guardian notification and consent are not needed. LEAs are cautioned about release of aggregate data when individual children's eligibility may be deduced, such as through the release of data about a specific classroom when the number of eligible children is small. Need to know. Although disclosure of meal status information is allowed through the National School Lunch Act to individuals who are directly connected with the administration or enforcement of a program, there must be a legitimate need to know. The intent must be to provide a service, or the intent must be to carry out an authorized activity. Note, eligibility information cannot be made available to all school officials as a general practice. Access must be limited to a student's teachers who are directly responsible for the administration of a federal education program or who are providing tutorial or other assistance under the educational program. Teachers, guidance counselors, principals, or other school officials who are not providing such assistance under the appropriate statutory or regulatory requirements cannot have access. Online data systems must have a method to prevent unauthorized access to free and reduced price eligibility status. Take a minute to look over these disclosure requirements. In this chart, you will see information about what may be disclosed and what the requirements for disclosure would be. It's a good idea to keep this chart for your reference in the event that you are asked to disclose information about students' meal statuses. Disclosures that require parental notification. LEAs must inform the adult household member who signed the application if they plan to disclose or use eligibility information outside the originating program. This may be done by issuing a general notification of potential disclosure or through a specific notification to disclose information to a particular program. Notice requirements. The notice of potential or specific disclosure may be included in the letter to the households that accompanies the free and reduced price application, on the application, or for children directly certified in the document informing households of their child's eligibility through direct certification. The notification must state they are not required to consent to disclosure, how the disclosure will be used, for instance, to enroll students in a health insurance program or other program. The decision to disclose or not disclose does not affect meal status eligibility. Disclosures that require household consent. Parents or guardians may always give consent for the disclosure of any or all of the information related to their children's eligibility status or the information the household provided through the free and reduced price meal eligibility process. Parents or guardians may request release of information to programs. The district or LEA must obtain written consent signed by a parent or guardian according to the guidelines below. A disclosure of all eligibility information to any other federal, state, or local program or individual not included in the National School Lunch Act requires household consent. Other programs that require parental consent are local level programs and activities, including local health and local education programs. For example, the disclosure of children's free and reduced price eligibility status to determine eligibility for free textbooks or reduced fees for summer school requires consent when these are local initiatives rather than state or federal programs. Household consent. The disclosure of information other than names and eligibility status to the programs authorized only to receive children's names and eligibility status also requires written consent. If the program is requesting more information than just the name and eligibility, consent must be obtained from the household. For example, districts, LEAs may disclose names and eligibility status to a federal education program, but if the program requests additional information such as family size or the basis of eligibility, districts, LEAs must obtain household consent prior to disclosure. Consent statement. The consent statement must be in writing and must contain the following: identify the information that will be shared and how the information will be used. It must be signed and dated. In the case of a child participant, the consent statement must be signed by the parent or guardian, even though the application for free and reduced price meals may be signed by any adult household member. Indicate that failing to sign the consent statement will not affect eligibility or rights to participate in the child nutrition programs. state that the information will not be shared by the receiving program with any other entity or program. Enable parents, guardians to limit consent to only those programs with which they wish to share information. For example, the consent statement could use a checkoff system by which the applicant could check or initial a box indicating they want to have information disclosed to determine eligibility for benefits from a specific program or programs. Disclosure to non-custodial parents. The district LEA cannot disclose the eligibility status or the source of the child's eligibility to the non-custodial parent without the consent from the parent household member who signs the application. An attorney's request would not be sufficient justification for the release of the application data. The sole exception would be under a court order or subpoena. LEAs should consult with an attorney to determine if disclosure may be required. Penalties for improper disclosure. According to Section 9B-6C of the National School Lunch Act, improper disclosure may result in a fine of up to $1,000 or imprisonment of up to 1 year or both. Improper disclosure includes publishing, divulging, disclosing, or making known in any manner or extent not authorized by federal law any eligibility information. Programs or entities who are authorized to receive meal status information must not disclose the received information to other programs. Penalties would apply if information is improperly disclosed. The reference for this presentation is the United States Department of Agriculture Eligibility Manual for School Meals, Determining and Verifying Eligibility, Section 5.